Good morning. Happy Sunday. We're going to go through a little common legal myth session with Dr. Law where he calls out my idiocy. And I, for one, love my idiocy being called out. Just so you are aware, this will be playing at 2x speed. The link to the video, as always, will be in the description. So if you miss something, you can always go back to the original video and watch it. You can all, and I encourage you to do that. I mean, our boy Dr. Law needs to make his dollary dues. I believe he does have monetization enabled, and you can also do this yourself, and you can slow down. Anyway, you can slow down my video if you want to hear him more. Now, I apologize. You can never please everybody all the time. The best thing that I found is to play the underlying videos fast because I talk slow enough and I don't want an hour-long video off of an 8-minute video. So with all that being said, let's get into the schooling session from Dr. Law.
So I got more common legal myths for you today. These first three come from some videos of Murby's where he is pretty much, exposing his idiocy again. So
you ever have one of those dreams where you go to school or work or whatever, and you're walking around at school or work, and then all of a sudden you realize that you've been exposing your idiocy all day? That's super embarrassing, and then you wake up in a cold sweat. I'm sure I'm going to be super embarrassed by the end of this.
So the first one is a federal affidavit must be notarized. So he's saying, first of all, that affidavits require a notarized signature. So, or I should say, are notarized, right, by notary. So I'm pulling up the affidavit of Benjamin Wish in Chili's case, and I don't see a notary's certification. So that's weird.
Yeah, that is weird. I don't know why he did that, and I don't speak for Benjamin Wish. But Benjamin Wish, last time I checked, isn't a dictionary or a statute or anything like that. So, okay, maybe he just grabbed a form. Maybe his paralegal just grabbed a form that would have been intended to be notarized or something. I don't know. Maybe he just got in the habit of calling it an affidavit and he just never changed his form. Who knows? I don't know. But this is just something that an attorney did. Unless, Dr. Law, you're suggesting that attorneys are always correct. In which case, thank you. Thank you. Yes, I am.
Why is that? Could it be because Benjamin doesn't know what affidavit is, or could it be because Murby's doesn't know? So if we refer...
I wonder if I don't know what an affidavit is. I'm sure he's going to school me and show me the definition of an affidavit.
To this thing called 28 U.S.C. Section 1746, unsworn declarations under penalty of perjury. So in federal civil procedure, an affidavit, unless it says specifically that it needs to be done by a notary public, does not need to be notarized. All it has to do is be made under attestation against perjury. So,
hold on a second. That was he went through this really quick. I mean, I don't think it said that. I don't think it said that, sir. If you do what lawyers like to do, and that's called read the language, it says whenever, under any law of the United States, or under any rule, regulation, order, or requirement made pursuant to law, any matter is required or permitted to be supported, evidenced, established, or proved by the sworn declaration, verification, certificate, statement, oath, or affidavit in writing of the person making the same, other than a deposition or an oath of office, or an oath required to be taken before a specified official other than a notary public. Such matter may, with like force and effect, be supported, evidenced, established, or proved by the unsworn declaration, certificate, verification, or statement in writing of such person which is subscribed by him as true under penalty of perjury and dated in substantially the following form. So you might have noticed a difference. So this one was declaration, verification, statement, excuse me, declaration, verification, certificate, statement, oath, or affidavit. See, down here we have unsworn declaration, check, declaration, certificate, verification, those are just backwards, or statement, but it doesn't say oath or affidavit. Isn't that weird? Isn't that weird? That's weird. Why is that? Why would they have changed that? So once you take away something, i.e. the sworn oath or affidavit, then all of a sudden it's no longer an affidavit. Isn't that weird? Isn't that weird? This is something that our boy discussing law doesn't do. This is a case. And this case cites Black's Law Dictionary, which is a dictionary, but it cites it to give a fairly recent general definition of what an affidavit is. An affidavit is a written or printed declaration or statement of facts made voluntarily and confirmed by the oath or affirmation of the party making it, taken before a person having the authority to administer such oath or affirmation. This is 22 CFR 92.22. This is not on point. This is specific to the ability of the Foreign Office, the Department of State, their Foreign Office, to provide notary services to people overseas. They have defined affidavit, though, and remember, a statutory definition of affidavit will override the general definition of affidavit provided by Black's Law. But you could just see, I'm just showing you this for, this is continuity. This is the general definition of affidavit. An affidavit is a written declaration under oath. It's made under oath, made before some person who has authority to administer oaths, without notice to the adverse party that may exist. One test of the sufficiency of an affidavit is whether it is so clear and certain that it will sustain an indictment for perjury if found to be false. An affidavit differs from a deposition in that it is taken ex parte and without notice, while a deposition is taken after notice has been furnished to the opposite party, who is given an opportunity to cross-examine a witness. This is going to come up later. A deposition is generally where you have the ability to examine, cross-examine, or redirect a witness. Whereas an affidavit is not. You don't. There's no ability to cross-examine a witness, i.e. there's no ability to examine, cross-examine, or redirect the witness. Now, when you're talking about affidavits, let me just zoom this in. This is from the California Secretary of State. This is the jurat form. Any jurat within the state, a jurat is the block of the notary for when they've administered an oath. So if they present, you walk in with your affidavit and you present it to the notary public in California, and they'll take your information. They'll have you sign their notary book. They'll check your ID, and then they'll have you swear it, and then they'll sign this block. And what does this block say? This block says, and it has to be substantially within this following form. Any jurat taken within the state shall be in the following form: subscribed and sworn to or affirmed before me this day, proved to me on the basis of satisfactory evidence to be the person who appeared before me. I.e., the notary has to identify the person who's taking the oath or affirmation, which doesn't seem to be terribly odd or wrong, does it? Hey, I'm gonna swear, I'm gonna take this oath. Well, first thing the notary is gonna do is make sure that you're actually the person who's taking the oath, or else how is the court going to be able to hold you in contempt? Remember, it has to be so clear and certain that it will sustain an indictment for perjury if found to be false. If you could walk in, the court says, hey, you signed this statement, this affidavit under penalty, or you signed this affidavit and you signed it under oath, sworn by a notary public. If you could just say, "Oh, that wasn't me," the notary never checked my ID, it wasn't me, then what use is it? And you're going to say, "Oh, well, John, this is in Massachusetts, and Kate and Josh are in Massachusetts." Well, this is the Massachusetts Notarial Act's forms of acknowledgement and certification. A notary public shall use a jurat certificate in substantially the following form in notarizing a signature mark on an affidavit or other sworn or affirmed written declaration. On this day, the name of the document signer personally appeared, proved to me through satisfactory evidence of identification, which were blah, 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 to be the person signing the preceding or attached document, yada, yada. So either in California or in Massachusetts, a notary public who is going to be issuing the oath or affirmation, because remember, it has to be a issued, confirmed by oath or affirmation taken before a person with the authority to administer such oath or affirmation. And this is about this one. They have give people the power to issue it. Taken before some person who has authority to administer oaths. So, like a court clerk, I guess, could in open court administer oaths. A judge could administer oaths. Or notary public, those are the big ones. There are probably others that I don't really care about right now, but you can see that that our boy here skipped through stuff. And if you think that there is no substantive difference, although homeboy does have LexisNexis, he has the full version of LexisNexis, and his PDM FID is 1530671. So I don't know if he's getting these through school, because he had Westlaw Edge previously. I am so jelly. These programs, these resources, I guess I should say, are super expensive. So I don't know how dude has access to these, but my God, I'm jealous. My God, I'm jealous. I would love to have access to these. Now, the sad thing is that even with access to these, he's still failing this bad. I don't understand it, but okay. But you can see also here, down at the second version, it says by unsworn declaration, certificate verification, or statement. They took out oath or affidavit because those are sworn. Those are by definition sworn. You can't have an unsworn affidavit that's valid, because in order to be valid, it's got to be sworn. That's just the long and the short of it. And the declaration under penalty of perjury isn't sworn. It has to be sworn by oath or affirmation by someone who has the ability to administer the oath or affirmation. So, sorry, Charlie.
So yeah, Murphy is 8 on that one, and probably the rest of them, right? So, but let's go through them.
Yeah, he got me there, boy. Whoo!
So a notary can't acknowledge a signature for an anonymous party. So that's not true. Like, I'm not a notary, and you should probably talk to one, Murphy's, but they're only required to first of all, there's so many different types of notary services, right? So typically you say, I want an oath, which is them swearing to a higher power. You want an affirmation where they're signing under penalty of perjury, or an acknowledgement where they're verifying that the identity of the person signing it and that they're
An oath or affirmation, no. So an oath would be like, I promise to support the Constitution of the United States and uphold the laws of the state of California, yada, yada. That's an oath. That's saying I will do something in the future. An affirmation is saying that this thing that I'm signing is true and correct. It's an oath to a higher power. What the fuck are you on about, homie?
actually signed the document. And then there's a combination of those, right? So if you're asking for acknowledgement that they're making sure the person signed it, the person can sign it however they want. So the most common form is in California is the acknowledgement. This just says that that the notary, that someone appeared and signed it, and there you go.
That's what the notary signs. It's like if you're signing a will, someone's doing a will signing, they want to have it notarized. That you don't have to in California have your will notarized. I would recommend it, but if if you if you're going to do the notary, the notary isn't saying that this will is true. They're just saying that, look, the person who signed the will did it in my presence, and I verified their identity. So it just makes it harder, if not impossible, for someone at court to later say, this was a forged document. Because you can call the notary could bring their book. They have a book of all these things showing who signed what, and they could match the document to the book and make sure that it's the same person who signed it in the book that the notary keeps and on the notarized document that left the notary and went with the person who purchased the services of the notary. So that's how that double check goes into place. And as we saw in this one, there is the acknowledgement of the mark. That's this one right here, where again they're just saying that they've identified the person. So, yeah, sorry, dude.
So like John Doe could, so I should say John Rietveld goes to the notary's office and says, I want to sign this as John
Rietveld. It's Rietveld, you moron.
Doe. Notary looks at John's driver's license. John Rietveld signs it John Doe, and then notary can't tell them how to sign their name. John Rietveld's name is going to be signed into the notary's journal, not John Doe.
No, so John Rietveld's name is going to be signed. So that's the signature. So they write on here before me. They insert their name and title. They say so on this date before me, Billy Bob McGillicuddy, Notary Public, personally appeared, and then the notary writes the name in. So you could sign whatever. You could put an X, but the notary will write your name in there. And on this one, on this day, the undersigned Notary Public, Bill Bob McGillicuddy, before me, the undersigned Notary Public, this person, the name of the document signer, personally appeared before me. So again, the Notary Public writes the name of the document signer in there. And then the document signer could put an X there.
Doe, and he should probably sign it the same way he signed the document as John Doe, but that really doesn't protect the anonymity anyway. So that's probably not going to do it. So you should talk to the notary. But how I understand it, would be done would be they would sign it John Doe, and then there'd be a third page that has the certification from the notary with an acknowledgement, and that third page would be filed under seal. So,
Again, I don't think in a civil case you could play that kind of game and hide evidence, have anonymous witnesses, because again, part of a witness's testimony. First of all, you don't do it by affidavit, but part of what the court has to do in determining whether or not on a motion that is going to be supported by affidavits or declarations, part of what the court has to do is figure out kind of basic credibility issues. And if someone is anonymous, I don't think that's really going to help their credibility. Now, I mean, your mileage may vary. You may think anonymous people are more credible, and that's great, but I don't think it's going to help anybody. And I don't think that the court's going to let anybody file anything under seal in this particular matter. And I'll wait to be proven wrong on that.
so that's how you do it. So it's not true. A notary can acknowledge a signature for an anonymous party. All right. So affidavit of a dead person is admissible.
So let's just say that Chile submits an affidavit, a notarized affidavit, but he submits the notary's page under seal. The entire reason for having that notary's signature, that notary page, is to prove to third parties, i.e. opposing counsel, the court, etc., that the person signing it, in our particular example, took the oath or affirmation so that they could be held to the same standards, penalty of perjury, as someone who was giving the same testimony in open court. So if you don't have that notary page, then why the F would you notarize it? You know what I mean? Like, it doesn't make any sense. It's counterintuitive. And again, it's not going to be filed under seal. So there you go.
And hearsay. So, Todd was saying, if I'm dead, whatever, what happens? And I pointed out, well,
Now, I just want to be clear that I did not say the affidavit of a dead person is inadmissible hearsay necessarily. I pointed out there are exceptions, and that those exceptions, as far as I could tell, did not apply to Todd Lyons. So I just want to be very clear about that. Go back and watch my original video. You'll see that I went through the exceptions and I applied them to Todd Lyons' particular situation. So I want to be very clear about that. I have not made a blanket statement that the affidavit of a dead person is inadmissible hearsay. I have not made that statement, but let's go ahead.
you can still use his affidavit. So Murbeast says, well, that's not true, because if you look at the federal rules and you're not reading it correctly and you don't have an annotated version and you skip relevant parts, that's not the case. So
I skipped relevant parts. Oh, and he's gonna show the annotations and he's gonna go through them for us, right? Right?
First off, Murphy says, well, the testimony that Todd gave that was against Chile would also be valid then. So
yes, if an affidavit is considered to be testimony given with the ability of the party it's being used against to examine, cross-examine, or redirect, if that is the case, then it goes both ways. But I don't think it applies. I don't think it's not testimony. So
you're confirming then that the other side had a chance to cross-examine them?
Hold on a second. Maybe I missed something.
Chile would also be valid then. So you're confirming then that the other side had a chance to cross-examine them, which is...
Well, I mean, if we completely ignore what cross-examining is, sure. If we just completely throw the definition of what cross-examination is out the window, sure. Absolutely then. I mean, what are definitions? Like, who really, let's just call anything cross-examining. Oh, well, you've met him before. You had the opportunity to ask him questions. So there you go. Well, Todd Lyons submitted an affidavit. Kate and Josh did not submit Todd Lyons' affidavit. Number one. And number two, even if they had, it is not, see part A was given as a witness at a trial, hearing, or lawful deposition, whether at the current proceeding or a different one. And that means you have to have both A and B. You have to have both parts apply. So let me hear you get A in there before you start talking to me about cross-examination, which isn't what happened, because cross-examination is in relation to trial, hearing, or lawful deposition. Dummy.
Exception, right? 804B1B. Yeah.
What? 804B1B. That's an exception. That's an exception. It's 804B1B. 804B, the exceptions. 1, former testimony. Former testimony. That's the whole thing. He gave you half of it. He completely ignored the and. So either he's stupid or he's lying, or both.
You also skipped over this one, a reasonable person making a statement that's contrary to their interest and that would expose them to civil or criminal liability.
What civil or criminal liability would Todd Lyons' affidavit made for Chile? What would that expose Todd Lyons to? I'm going to wait for your explanation, because I don't know of what civil or criminal liability it would expose Todd Lyons to.
That one counts as well. And then...
So he's just going to say it counts. He's just going to say it counts. Just, it counts. There's civil or criminal liability. Okay, what? Nope, it just counts. Loser.
There is, if you actually have an annotated version of the rules, and you scroll down, and you look at death, illness, or infirmity, there's a slew of cases. A lot of them do talk about deathbed, and as also the other side having the opportunity to cross-examine, which we've already.
Deathbed, yeah, I had talked about deathbed. The deathbed exception was in anticipation of dying. What was it called? Statement under belief of imminent death. So, so I gave you the example of someone who'd been shot and wrote the name of their murderer in blood, right? Because you'll see that a statement under belief of imminent death, the deathbed statement, it is in a prosecution for homicide or civil case, a statement that the declarant, while believing the declarant's death to be imminent, made about its cause or circumstances. About its cause or circumstances. What are they referring to about its cause or circumstance? Well, their imminent death. Their imminent death. So a statement in a homicide or civil case, notice how they are using just those two things, homicide or civil case, about what the dying person believes are the cause or circumstances of their death. Now, I don't know how that applies to Todd Lyons or the affidavit he made for Chile. Let's see if we can't look at some of these. Handwriting expert became unavailable under Rule 804 due to severe illness. Okay. Was that person, was that handwriting expert, had he been cross-examined at deposition? Normally you depose experts. In an action against commercial packing house based on theories of breach of contract, violation of state antitrust laws, yada, yada, a trial erred in allowing 3 witnesses to testify to statements made by a former manager of defendant company who, although admittedly unavailable due to ill health, had not made the statements under oath, had been responding to questions of his attorney which would normally elicit favorable responses, and had made statements in a situation where there would be subtle pressure to be in accord with other favorable witnesses in the attorney's offices. So it wasn't made under oath. Now again, he's going to suggest that a statement signed under penalty of perjury is made under oath. It's not. A statement made under oath is where someone who has the ability to swear you in, to say, do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, or do you swear or affirm that the statement that you're signing today is true? Something along those lines. It's not just I declare under penalty of perjury that the foregoing is true and correct under the laws of the state of California, whatever, blah, blah, blah. It's not that. It's where someone issues you an oath that you saw, that you attest, or that you, oh God, words are hard. It's early. It's early. It is where someone administers an oath. That's what it is. It's where someone administers an oath. Anyway, we'll move on.
Said that Kate's team has had a chance to cross-examine him, but there are also plenty of exceptions that don't cover that. So it's pretty much true that you definitely can use.
It's pretty much true that you definitely can use, because he scrolled through a list of annotations and he didn't go through any single one of them that even remotely reflected the circumstances of Todd Lyons' affidavit. Congratulations.
So it would not be in a civil hearsay. All right, so then other people, because there was money collected to get cops have duties or whatever out of jail, people were saying, well, you donate all this money, what's going to happen when he gets that money back from the bail bondsman? Who's that going to go to? Is he just going to pocket it? So I have the myth as when you pay a bail bondsman 10%, you get the money back. So no. So
did he pay the bail bondsman 10%? If you do pay the bail bondsman 10%, then that's just the fee. You don't get that money back. That's correct. But if he actually paid, if Chile paid the bond, then yes, that money would come back. Anyway, that doesn't really, I don't really care about that. That's not a legal thing. I don't know why he's calling that a legal myth. It's not a legal thing. That's a contractual issue between you and the bail bondsman. Anyway, that's all I got for you today. Thanks for watching. Have a great day.